Hello and welcome back. GovDoc News. No opinions, just facts and summaries, government documents. You do the rest. We are back with another Supreme Court order from October 14th, 2025 in the case Humphreys v. Emmons. All right, another denial of certiorari here from the Supreme Court. Humphreys of Humphreys v. Evans was convicted for murdering two women during a robbery in a model home, and the prosecution sought the death penalty in this case. During jury selection, a juror named Chancey disclosed that she was a victim of an attempted rape and robbery, but claimed it would not affect her impartiality. She specifically said that her attacker did not physically harm her, and that she could fairly consider all sentencing options, life with parole, life without parole, or the death penalty. During penalty phase deliberations, however, Chancey revealed to other jurors that her attacker had indeed assaulted her, contradicting her earlier statements. Apparently, Chancey was fixated on the death penalty from the start of the deliberations, refusing to consider any other options. She intimidated other jurors, yelling, cursing, and using her personal experience to argue that Humphreys, quote, deserved to die, unquote. She also falsely claimed that Humphreys would be paroled if the jury did not unanimously choose death, which was incorrect under Georgia law. Initially, the jury was leaning toward life without parole, 11 of the 12, but Chancey's behaviors apparently caused chaos in the deliberation room. Chancey revised a jury note to avoid a mistrial, threw victims' photos, and personally attacked other jurors. Screaming and crying were audible, one juror even punched a wall, and the foreperson requested to be removed due to Chancey's hostility. Despite these issues, the trial court gave an Allen challenge, basically an instruction to keep deliberating, and denied a mistrial. The jury eventually returned a unanimous death penalty verdict. Evidence of Chancey's misconduct came from juror affidavits and testimony after the trial. However, Georgia has what's called a no impeachment rule that generally prohibits jurors from using their own statements or testimony about what happened during jury deliberations to challenge or impeach a verdict after it has been reached. Therefore, the evidence uncovered of Chancey's behavior was barred from being used to challenge the verdict. On top of that, Humphrey's lawyers failed to raise the juror misconduct issue on direct appeal. So it was considered procedurally defaulted or not raised in time during the state habeas review. The Georgia Supreme Court also ruled that Humphrey's appellate counsel's failure to raise the issue was not prejudicial because the no impeachment rule would have blocked the claim anyway. In response, Humphreys sought federal review of the case, but the 11th Circuit Court of Appeals upheld the state court's ruling, citing procedural default or not raising the issue in time. It also appeared that the 11th Circuit applied deference under the Anti-Terrorism and Effective Death Penalty Act, which limits federal courts' ability to review state court decisions. However, there was some confusion about whether the AEDPA deference should apply to the procedural default issue, specifically whether ineffective assistance of counsel could excuse the default. But upon review, the Supreme Court has declined to hear the case. Humphrey's petition focused on whether the 11th Circuit incorrectly applied the AEDPA deference to the procedural default question, not the juror misconduct issue directly. Humphreys is not currently scheduled for execution, but he remains on death row in Georgia Diagnostic and Classification Prison. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you in a little bit.